Well, I want to say, wow, what a fantastic gathering of minds and presentation of ideas today. We've been working on this event for over a year, and I have to say, my feeling over the last year has felt similar to the night before a childhood birthday party. The anticipation you feel the night before when you know a lot of your friends are coming over and you're going to get lots of great presents. And we've definitely had the great presents so far today. Again, let's have a hand for our contributors and speakers today. They did a fantastic job. Thank you all. We've opened our great presents today, but one of the best part of those birthday parties is when you look in the corner and you see that big wrapped box, and you can't wait to wrap that. Well, we still have that left with the Honorable Justice Barak. As you know, Justice Barak served as the Attorney General of Israel and as a justice on the Israeli Supreme Court, and then from 1995 to 2006 as the President of the Israeli Supreme Court. We've all heard what others think Justice Barak would say on issues today, but finally we get to unwrap that present and hear it from him himself. Please give a hand for the Honorable Justice Barak.
Good evening, and thank you very much for coming, for participating. It's a good start. The light comes. I would really want to thank the law school and the law review for having this kind of event. I don't know how the idea came to you. It was a surprise for me. But, and it embarrassed me a lot, you can imagine. But, you know, it was a nice kind of embarrassment. If you have to be embarrassed, let it be this way. So thank you for the law school and thank you for the law review. And of course, I would like to thank very much my colleagues, friends, who came from all parts of the world, so to speak, to participate in this event. And thank you very much. I know how busy you are and what it means to come to here and express your views on different topics. Thank you very, very much. During the day's discussion, several questions were raised with anticipation that I will answer specific questions, which I totally refuse to do. For two reasons. First of all, I still find myself quite limited in my range of options. Once a judge, always a judge. And there are things that I can't talk. So, Owen, my mistakes. I made many mistakes. I hope I made mistakes, because it's just a sign that I'm human. But I'll start now listing my mistakes. Tomorrow, those questions will be argued in the Supreme Court. Here he himself said it was a mistake. So I prefer more time to pass and to have a much greater distance between my retirement and when the questions will come up. I also think that by giving you specific answers, you will not see the general picture. So what I thought to myself is, in the short time I have, is to give you a general view about my judicial philosophy. I mean, how I was deciding those cases. I was sitting on the Supreme Court 28 years. It is a very long period. And I was thinking about what I was doing. I was conscious about it. I met many judges from many, many courts in the world. and I participated in many, many dialogues that you mentioned here, talking with judges, writing to judges, sitting with judges in different conferences, and expressing my views and learning from them. So let me, in a very short time, to transfer to you my basic ideas that shaped my thinking about judging on a Supreme or a Constitutional Court. So let me start with a proposition which I know many people criticize me for, but I just repeat it. Law is everywhere, though law is not everything. Law is everywhere in the sense that all human conduct is subject to legal norms. Even when an activity such as friendship is controlled by the autonomy of the will, that autonomy exists within the law. Without it, everyone would have the power to invade this autonomy. However, law is not everything. There is religion and there are morals. The law is the means to organize life between members of a given society at a given time. Law is the tool that allows society to function. Each society must determine the appropriate character of the relationship in that society. Naturally, different societies have different views regarding what are the appropriate social relationships. There are those who would like to see human rights at the focus and the foundation of these relationships. Others see beliefs in God and the observing of the commandment as the necessity guide. There are those who would emphasize the good of the state as a whole, and there are those who would concentrate on the good of the individual. It is necessary to reach a national compromise when choosing between those conflicting values and principles. Indeed, human beings are complicated social beings. Their life is complex. Their objectives are multidimensional. We want freedom of religion and we want freedom from religion. We wish to ensure both the common good and the individual good. But as attaining everything is impossible, we must choose and determine what our national priorities are. We need a balance between our priorities. Law in a democracy reflects the national balance the society has achieved. This national balance is based inter alia on the recognition of the basic human rights on the one hand and the conservation of the existence of the state framework on the other. Democracy is not simply majority rule. Democracy is majority rule intended to ensure human rights in the context of a living, breathing state. The state must not be sacrificed on the altar of human rights. Human rights are not a prescription for national self-destruction. However, human rights must not be sacrificed on the altar of the state. The state exists for its individuals. Balance is needed between the common good and the individual good, between the good of each individual and that of his fellow individuals. Naturally, this balance varies from one society to another, and in the context of a given society, it varies from one time to another. It is influenced by the dangers that the society faces, by its social structure, by its collective history, and by other factors which make up society's identity. Democracy is based on separation of powers. The meaning of this principle is twofold. First, a demarcation between the various branches of government is recognized, whereas each government branch is assigned a role as its main and principled. Second, there is a reciprocal relationship between the various branches, such that each branch checks and balances the other branches, safeguarding the individual rights. In that context, the principal function of the judicial branch is resolving disputes according to law. As a byproduct of that resolution, the judicial branch must determine the law according to which the dispute is to be settled. This extends The extent to which it determines the law while resolving the dispute varies from one legal system to another and is derived from its traditions and cultures. Every legal system recognizes the legitimacy of judicial determination of law by way of interpretation of provisions of the Constitution, statutes, contracts, or will, which apply to the dispute. In common law legal system, the creation of the common law is a legitimate function of the judges. In many cases, determining the law according to which the dispute is to be settled does not entail any judicial creativity whatsoever. The law before and after the dispute resolution is the same law. In determining what the enacted law is, the judge merely states the existing law. The judge is, to use Montesquieu's words, the mouse of the legislature. The judge's actions are declarative and not creative. Only in a small minority of cases does the determination of the enacted law involve judicial creativity. In these cases, and within the development of the common law, the law prior to and after the dispute resolution is not the same law. The judge does not merely declare what the existing law is, the judge creates new law. In such cases, the judges engage, incidentally to deciding the case, in judicial lawmaking. Thus, these are the hard cases. How will a judge know that in a certain situation there is judicial discretion, this creativity I was talking about? When will the judge determine that two or more options are legal in such a manner that the choice between them requires judicial discretion? My answer is that the existence of judicial discretion is a result of the legal community's view in a given legal system. Owen, you developed this idea of the legal community. The legal community is a normative concept that reflects the fundamental views, principles, rules of interpretation, and social consensus regarding the judicial activity in a given society at a given time. An option is legal if it is viewed as such by the legal community. Judicial discretion is necessary. It is impossible to build a legal system without judicial discretion. The history of the common law is the history of judicial discretion. Interpretation entails judicial discretion. Judicial interpretation without judicial discretion is a myth. The ambiguous and vague nature of language, including the language and the rules of interpretation, and the lack of consensus regarding the rules of interpretation, their source and their internal relationship, require recognition of an interpretive discretion. Man's wisdom cannot create a general legal principle that can provide an unequivocal answer without the use of discretion regarding the infinite amount of situations, some of which cannot be expected in advance, to which a principle may apply. Judicial discretion is never, never absolute. Even when the judge has the freedom to choose between one interpretation and another, or one common law rule or another, the judge cannot choose between them however he pleases. The judge cannot toss a coin, of course. The judge must employ discretion within the boundaries set out by the law. He or she must act in the framework of substantive and procedural restrictions. Indeed, judicial discretion, like any discretion by state organs in a democracy, is always, always limited. A judge must act objectively. Judicial discretion exists only in the framework of the judge's objective activity. The judge must act without favoritism or conflict of interest. But the objectivity requirement is even more comprehensive than that. A judge is objective when the choice of a given possibility among the spectrum of possible options is made because it is called for by a normative requirement external to the judge. Such a requirement is necessitated by the fundamental attitudes of the society in which the judge lives. It is the fruit of society's deep understanding regarding justice and public morals in the society in which he or she lives. When even this standard presents more than one possibility, the judge has no choice other than to choose the possibility that appears to him to be the best. This does not forfeit the need of objectivity. The judge has already gone through an objective stage. Only after he has done so and found himself faced with a number of possibilities must he act subjectively. Then he is alone, and then he is very, very lonely. In exercising their discretion, judges should aim to achieve two main objectives. The first is to bridge between law and life. It was mentioned in the morning. Thus, when interpreting a constitution or a statute, the judge should give the text a dynamic meaning, one that strives to bridge the gap between law and society's changing reality, without changing, of course, the text itself. In doing so, the judge must balance the need for change with the need for stability. As Professor Roscoe Pound expressed this well more than 80 years ago, I cite, "Hence, all things about law has struggled to reconcile the conflicting demands of the need to stability and the need of change. Law must be stable, yet it cannot stand still." End of citation. Stability without change is decline. Change without stability is anarchy. The role of a judge is to help bridge the gap between the needs of society and the laws without allowing the legal system to decline or collapse into anarchy. The judge must ensure stability with change, and change with stability. Like the eagle in the sky, maintaining stability only when moving, so too is the law stable only when it is moving. Achieving this goal is very, very difficult. The law's life is complex. It is not mere logic. It is not simple experience. It is logic and experience together. The law's evolution throughout history must be cautious. The choice is not between stability and change. It is a question of how fast the change occurs. The choice is not between rigidity and flexibility. It is a question of degree of flexibility. The judge's second objective, and this was mentioned here too this morning, is to protect the Constitution and democracy. If we want to preserve democracy, we cannot take its existence for granted. We must fight for it. The assumption that it won't happen to us can no longer be accepted. Everything can happen. If democracy was disallowed and destroyed in Germany of Kant, Beethoven, and Goethe, it can happen anywhere. If we do not protect democracy, democracy will not protect us. I don't know whether the judges in Germany could have prevented Hitler from coming to power in the 30s. But I do know that the lessons of the Holocaust and of World War II era helped promote the idea of judicial review of legislation action and made human rights crucial. These lessons led to the recognition of a defensive democracy, or even a militant democracy. And it shaped my belief that the main role of a judge in a democracy is to maintain and protect the Constitution and democracy. In one of my judgments, I wrote, "The struggle for law is never ended. The need to watch over the rule of law exists all times. Trees that we have nurtured for many years may be uprooted with one stroke of the axe. We must never loosen the protection of the rule of law. All of us, all branches of government, all parties, all fractions, all institutions must protect our young democracy. This protective role is conferred on the judiciary as a whole and on the Supreme Court in particular. Once again, we, the judges of this generation, are charged with watching over our basic values and protecting them against those who challenge them. End of citation. I believe that the protection of democracy is a priority for many judges in modern democracies. The judicial protection of democracy in general and of human rights in particular is characterized of most developed democracies. Legal scholars often explain this phenomena as an increase of judicial power relative to the power of other branches. This change, however, is merely a side effect. The purpose of this modern development is not to increase the power of the court in a democracy, but rather to increase the protection of democracy and human rights. An increase in judicial power is an inevitable result because judicial power is one of the many factors in a democratic balance. But how should judges realize their role? How should this double function be realized? The means of realizing the judicial role must be legitimate. The principles of the rule of law applies first and foremost to judges themselves. The tools which we build our structures are very, very limited. Our power to fulfill our role depends on our ability to design new structures with the old tools or to create in its limited discretion new tools. Sometimes there is a great similarity between the new structures we build with the old tools and the old structures we know from the past. We tend to say that there is nothing new under the sun and that the legal pendulum swings to and fro before returning to its point of origin. But these analogies are inappropriate. These structures always are new. There is no return to the point of origin. The movement is always forward. Law is in a constant motion. The question is merely regarding the rate of its progress, its directions, and the forces propelling it. Moreover, sometimes we succeed in creating new tools. Here, law's genius is evident. But such inventions are few and far between. Usually, we come back to the old tools and use them to resolve these new situations. The most important tool is interpretation. The Supreme Court's main activity nowadays in civil law and common law countries is interpretation, construction. This is true of both civil law and common law legal systems. Interpretation is the main tool used by judges to fulfill their role. The key question is, what is the proper system of interpretation? Neither the common law nor the civil law systems have a satisfying answer to that question. It seems to me that the solution lies in the answer to another question. What is the aim of interpretation? My answer is that interpretation's aim is to realize the law purpose in a way that will bridge the gap between law and society and will protect the Constitution and democracy. Hence, my theory of interpretation is the purposive theory of interpretation. In constitutional law, it means that the purpose of the constitutional text is its subjective historical purpose and its objective modern purpose. How should the Constitution be interpreted when the subjective purpose conflicts with the objective purpose? My answer lies in the unique character of the Constitution. A Constitution enshrines a special kind of norm and is found at the top of the normative pyramid. Difficult to amend, it is designed to direct human behavior for years and years to come. It shapes the state's appearance and its aspirations throughout history. It determines the state's fundamental political views. It lays the foundations for its social values. It determines its commitment and orientations. It reflects the events of the past. It lays foundations for the present. It determines how the future will look. It is philosophy, politics, society, and law in one. How does a constitution's unique character affect its interpretation? In determining the purpose of the Constitution, how does its distinctive nature affect its relationship between the subjective and the objective element? My answer is this: one should take both subjective and objective elements into account when determining the purpose of the Constitution. The framers' original intent at the time of drafting and the original understanding at that time is important. One cannot understand the present without understanding the past. The original understanding lends historical depth to understanding the text in a way that honors the past. The original understanding, however, exists alongside the fundamental views and values of modern society at the time of interpretation. The Constitution is intended to solve the problems of contemporary persons. To protect their freedoms, it must contend with their needs. Therefore, in determining the constitutional purpose through interpretation, one must take into account the values and principles that prevail at time of interpretation, seeking a synthesis and harmony between past understanding and present principles. We return then to the original question: what is the proper relationship between subjective and objective elements in determining the purpose of the Constitution, when the subjective and the objective pull to different directions? In my opinion, greater weight should be accorded to the objective purpose. Only by preferring the objective element can the Constitution fulfill its purpose. Only in this way is it possible to guide human behavior through generations of social change. Only in this way is it possible to balance the past, the present, and the future. Only in this way can the Constitution provide answer to modern needs. Admittedly, the past influences the present, but it does not determine it. The past guides the present, but it does not enslave it. Fundamental social views derived from the past and woven into social and legal history find their modern expression in old constitutional texts. Various courts have issued opinions in the same spirit, including the Canadian Supreme Court, the Australian High Court, and the German Constitutional Court. This is the purposive interpretation that I espouse. It does not ignore subjective purpose or original understanding in constitutional interpretation, but it does not give it the controlling precedent either. The weight of the subjective purpose decreases as the Constitution ages and becomes more difficult to change. In interpreting such constitutions, the preferred objective purpose reflects deeply held modern views in the legal system movement through history. The Constitution thus becomes a living constitution or a living tree. Indeed, constitutional interpretation is a process by which each generation expresses its fundamental views, formed with its past in the background. The interpreter honors the past through his desire to maintain a connection with it. Nonetheless, the ultimate purpose is modern. By stressing the importance of the objective purpose of the Constitution, the rule of interpretation as used by judges enables the judiciary to fulfill its role in bridging the gap between law and society and in protection the Constitution and democracy. I have found comparative law to be of great assistance in realizing my role as a judge. We talked about comparative law. The case law of the courts of the United States, Australia, Canada, United Kingdom, Germany, have helped me significantly in finding the right path to follow. Indeed, comparing oneself to others allows for great self-awareness. With comparative law, the judge expands the horizons and interpretive landscape. Comparative law enriches the options available to us. In different legal systems, similar legal institutions often fulfill similar roles, and similar legal problems such as hate speech, abortion, and how to fight against terrorism arise. To the extent that those similarities exist, comparative law becomes an important tool with which judges fulfill their role in a democracy. Moreover, because many of the basic principles of democracies are common to democratic countries, there is a good reason to compare them. Indeed, different democratic legal systems often encounter similar problems. Examining a foreign solution may help a judge choose the best local solution. This usefulness applies both to the development of the common law and the interpretation of legal texts. The importance of comparative law lies in extending the judge's horizons. Comparative law awakens the judge to latent potentials of their own legal system. It informs judges about the success and failures that may result from adopting a particular legal solution. It refers judges to the relationship between a solution to the legal problem before them and the legal and moral problems. Thus, comparative law acts as an experienced friend, just as an experienced friend. Of course, there is no obligation to refer to comparative law. Thus, the South African Constitution provides that when courts interpret the Bill of Rights, I cite, must consider international law, may consider foreign law, end of citation. Additionally, even when a comparative law is considered, the final decision must always be local. The benefit of comparative law is in expanding judicial thinking about the possible arguments, legal and moral trends, and decision-making structures available. While working as a judge, I have found a good philosophy a very practical tool in solving hard cases which the judge has discretion. A philosophy of life and a philosophy of law assist the judge in understanding life and law. As to philosophy of law, I found myself having an eclectic approach. It contains components from each of the main theoretical doctrines. In my opinion, the relationship between members of society and between society and its members is complicated and complex to such an extent that it cannot be described by one single point of view. Human experience is too rich to be limited to one theory. In my opinion, the naturalist, positivist, realist, and neo-realist, members of historical, economic, or sociological school of law, all reflect from different angles the amazed human experience. Each of them has truth in it. One can theoretically agree with each of them, but there arises a need to balance between the various views. According to my approach, the solution is not found in one single independent theory. One must take certain components from each of them of the main theories while determining the proper balance between them. None of these theories can remain pure. Balancing is always needed. It may be that this eclectic philosophy is a philosophy in its own right. Whatever the case may be, in my opinion, the law as a normative system has a role in society. It is intended to ensure functional social life. It contains order and security along justice and morals. My pluralist approach teaches me that there is no consensus regarding the relative weight of those values and that different people have different opinions of that subject. Democratic form of government determines which institutions and organs are assigned the role of determining such relative weight. Most important for judges is to articulate to themselves their judicial philosophy. By judicial philosophy, I mean a system of non-obligatory considerations that will guide the judge in exercising their discretion. These are the set of thoughts about how to exercise discretion in hard cases. Judicial philosophy is an organized thought about the way in which a judge is to contend with the complexity of the hard cases. In my experience, the majority of judges have such a judicial philosophy. For most, it is an unconscious philosophy. I strive to raise judicial philosophy onto the realm of consciousness and subject it to public critique. The judge's judicial philosophy is closely intertwined with their personal experience. It is influenced by their education and personality. Some judges are more cautious than others, and others are less so. There are judges that are more readily influenced by a certain kind of claim than others. Some judges require a heavy burden of proof in order to depart from the existing law, while others requiring a lighter burden of proof in order to do so. Every judge has a complex life experience that influences his or her approach to life, and therefore influences his or her approach to law. There are judges for whom considerations of national security or individual freedom are weightier than for other judges. There are judges whose personal makeup obliges order, and as a result, they require an organic development and evolution of the law. There are judges whose personalities places great importance on the proper solution, even if they reach that solution in a non-evolutionary fashion. There are judges whose starting point is judicial activism. There are judges whose starting point is self-restraint. Please note, starting point, not end point. There are judges who give special weight to considerations of justice in the general sphere, even if it creates injustice in the individual case. Other judges emphasize justice in the individual case, even if it does not fit in with the general justice found in the basis of the norm. One must always remember that judicial philosophy is relevant only in the realm in which the judges have judicial discretion. It works only in those cases where the legal problem has more than one legal solution. It is relevant only in hard cases, in which the judge strives to achieve the optimal solution. Judicial philosophy aims to bring us to this safe space. It is a main compass that directs the judge consciously or unconsciously in discovering the solution to hard cases with which he is confronted. Professor Freund wrote, I'm citing, "The most important thing about a judge is his philosophy. And if it is dangerous for him to have one, it is at all events less dangerous than the self-deception of having none." End of citation. I regarded myself as a judge who was sensitive to his role in a democracy. I took seriously the task imposed upon me to bridge the gap between law and society and to protect the Constitution and democracy. Despite frequent criticism and frequent dissent that frequently descended to levels of personal attack and threat of violence, I have continued on this path for 28 years. I hope that by doing so, I was serving my legal system properly. Indeed, judges in highest court must continue on their path according to their conscience. Judges are guided by their North Star, the fundamental values and principles of constitutional democracy. They bear a heavy responsibility on their shoulders. But even in hard times, they must remain true to themselves. I discussed this duty in an opinion concerning whether torture may be used. We mentioned it here in our discussion. I discussed the duty in an opinion considering whether torture may be used on terrorists in a ticking bomb situation. My answer, and the answer of the court, was no. And in my judgment, I wrote, and with this I'll finish, I'm citing. Deciding these applications has been difficult for us. True, from the legal perspective, the road before us is smooth. We are, however, part of Israeli society. We know its problems, and we live its history. We are aware of the harsh reality of terrorism in which we are at times immersed. The fears that our ruling will prevent us from properly dealing with terrorists troubles us. But we are judges. We demand that others act according to law. This too is the demand we made of ourselves. When we sit at trial, we stand on trial. Thank you.